Hi, this is Elliot, and today I'm going to be talking about a civil wrongful death lawsuit that's been filed up in Buffalo following the shooting in 2021, a racially motivated shooting in a supermarket there. But it's a wrongful death lawsuit that alleges that social media companies promoted white supremacist materials that radicalized the shooter. Now, to be clear, the lawsuit isn't just against the social media companies, and it's an interesting one because it goes after the social media companies, the parents of the shooter, the armorer who sells sort of body armor to the person, to the shooter, Peyton Gendron, and also the gun store that sells him the firearms. Now, the most novel legal theory comes up in the context of the social media companies, and we'll talk about those in a second. But first, let's just back up. Do you remember 2021? Peyton Gendron went to the Tops supermarket in Buffalo, New York, shoots a lot of people, ends up killing 10 people with a clear racial motivation. There's even a point at which he shoots somebody that's sort of on the ground, and he walks up to the person, sees that it's not a black person, and apologizes to them, says, "I'm sorry," and then goes on and sort of kills other folks. Really horrific shooting. Now, he has already pled guilty to the homicides and has received life in prison without parole. He's going to jail and not getting out. So the question is, what do you do now and what happens with him next? Now, it's not uncommon when people die, certainly in the case of homicides, to file a wrongful death lawsuit. It's a civil suit where one party sues another for money or some other damages because of the fact that the defendant was in some way responsible for the death in a civil manner. It's sort of not a crime. It's a little bit different. And it doesn't even need to be a crime. If someone has a serious accident at your house or something flowing from your negligence, of course, you can be sued for a quote unquote wrongful death as well. And the standard typically, it's going to vary from state to state, but the standard really is, were you reasonably aware that the actions you caused or the omissions in your behavior, things that you chose not to do or just were negligent in doing, reasonably could have led to the death of another person? So now let's bring this back to Buffalo and talk about this wrongful death suit. And the armorer and the gun store, we can put those aside because they're pretty straightforward. It's what the lawsuit says, brought by a number of parties, including the Giffords Law Center in honor of Gabby Giffords, a member of Congress who had been shot several years ago. The lawsuit alleges that these people who sold these items to him sold them knowing that he would go on and commit crimes. They allege that he made comments at the time of purchasing, for instance, in the context of the firearm, "I'm going to modify this firearm and go and shoot people with it." Now, those allegations are a little thin. They don't have recordings of the conversations. They don't have great witnesses on it, but they do allege that he made comments at the time of purchases that really should have tipped off these sellers. So we'll see what happens with them. That's the armorer and the gun store that sells the firearm that he ends up modifying, quite frankly, before going on. The parents are interesting in this matter because the lawsuit alleges that the parents were absolutely put on notice that Gendron would have gone on to commit homicides. Number one, he had said, and is recorded as having said at some point, that he was going to commit a murder-suicide. And his parents were aware of that fact, and so aware of it that they had him submitted for psychiatric evaluation. He'd been evaluated on account of the comments he'd made. He obviously had the firearms, and his parents were aware of the number of firearms and armor and weapons that he had amassed. Now, again, as just about everybody who's watching this knows, it's not unlawful to possess firearms or to own firearms or to buy them in America. But at a certain point, when an individual has amassed a great number of them and committed, or at least stated that he intends to use them to commit acts of violence, certainly a red flag ought to go off. And you could be held accountable for your negligence in not reporting this individual to authorities. And moreover, the parents had information that he had engaged in serious, vicious acts of cruelty to animals. The lawsuit lays out a really gruesome story, frankly, involving a cat that he had, won't even go there. But as many people know, evidence of cruelty to animals is itself often indicative and evidence of a future of violence or cruelty to other human beings. So the evidence was there, the parents, that's also relatively straightforward. So let's turn to the social media companies. And when you think of lawsuits against social media companies, often the question that comes into people's minds is, well, you enabled or turned a blind eye to the conduct, therefore you ought to be held accountable. And it's a little bit complicated because of laws that protect free speech. And social media companies often say, we do our best to moderate and regulate content or the content of our websites or our apps, but we can't be responsible for everything everybody says, right? And the law does protect that. Aha! So the parties here did something a little bit different, and they said, no, this is more like a product that you designed badly, and you designed it so badly that it ended up leading to people getting hurt. You designed your algorithm to promote only the most aggressive, most violent materials based on engagement and what people want to click on and want to see. And by doing that, you ended up encouraging or at least enabling violent activity. And they go in depth in this lawsuit saying that based on how aggressively people want to keep clicking, who are people, sort of vulnerable people who are prone to committing acts of violence, are more likely to click on acts of images of violence, that they're encouraged or enabled. And they also make the point that live stream shooters are almost always motivated by other live stream shooters. So the mere fact that live streaming appears on websites makes people more likely to want to go ahead and do so. The easier way to think of this, when I talk about a product defect, think about, you hear all the time about defective products, right? A lot of people with kids think about strollers that have the lock that's designed in an improper way and hurts children's hands, or even more obviously, an airbag. Some cars have airbags that are just designed badly. Do you remember from the 1980s, Audi with anti-lock brakes that were just designed badly? In each of these instances, plaintiffs were able to go to the company and say, your product is designed so unsafely that even someone who's using it properly is at a serious risk of being injured. Well, that's what the lawsuit says here. It's essentially saying it's tort liability, that you have just designed such a bad product, such a dangerous product, that people are going to get hurt and did get hurt and are responsible here. That, I will say and admit, is a novel new legal theory. We will see how it comes out. It's never been tested or tried before, but a lot of people who are frustrated with the pace of movement on gun safety are taking more novel approaches to addressing some of these instances in which people are killed by firearms or by shooters, and who are acting, frankly, within what they believe to be the bounds of the law. So we'll see what comes of this and whether it ends in nothing or a settlement, or, as the parties have asked, goes to trial. And what happens when Facebook and YouTube and Snap and Discord and all these parties who have been sued here put on evidence and depositions saying, well, this is how we designed our product. And yes, we might have been aware that occasionally there are mass shootings, but I don't know, we're just not. We'll see what happens. But part of the fascinating thing that non-lawyers may not realize about the litigation process is that none of this stuff comes out of nowhere. Parties have to think creatively about the best way to bring a lawsuit. Every lawsuit is unique, and this is certainly a unique one. So unique, although something grammatically can't be so unique, but you'll hear me here. This one is so novel that it may not work, but you never know. So we shall see what the next steps are. We will keep an eye on this. This one's, given the number of parties and the number of this is not going away for months, if not years. So stay tuned and we'll keep talking about it. Thank you so much for watching. Take care.
Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.